Good morning, everyone. Welcome to the Springfield public hearing on the earned sick time regulations. Today is May 29th. It is 10:43, and we're going to begin the hearing. My name is Jocelyn Jones. I'm the Deputy Chief of the Fair Labor Division in the Attorney General's office. With me to my left, the far left, is Marconi Almeida Barros, who is the Director of Community Engagement for the Attorney General's office. Mike Firestone, to my near left, is the Director of Strategic Initiatives in the office. To my far right is Chris Barry Smith, First Assistant to the Attorney General, and to my immediate right, the Attorney General, your Attorney General, Maura Healey. Okay. Just a couple things to bear in mind. This is a recorded hearing, so all testimony will be on the record for public record purposes. And at the end of the hearing, many of us will be staying to answer any questions that people might have, to have a discussion about the law and the regulations to the extent that people want to. So thank you very much. And with that, I will turn it over to our Attorney General.
Thank you, Jocelyn. Good morning, everyone. Thank you all for being here. I'm delighted to be here in Springfield. I was here yesterday and have the pleasure of being here today as well. And I want to thank you all for coming out because this is really important. This is a law that was passed by the voters last fall, and the statute directed our office, the Attorney General's office, to develop regulations to actually implement the law. And we've worked really hard with a clear goal in mind. We've wanted this to be a very transparent, collaborative process where we are hearing from all stakeholders impacted by this law. This is one of nearly a dozen public hearings that we are holding across the state. In addition to the public hearings, we've already had a couple dozen listening sessions across the state, and it's very important because we continue to learn and continue to be informed as a result. In the past several months now, we've heard and spoken with and listened to worker advocates as well as employers from all many different segments of business industry and of all different sizes. We've also consulted with payroll companies and human resource professionals. And since posting our draft regulations and frequently asked questions on our website on April 24th, we have heard from any number of others, hundreds of others, in fact, employees and employers. So I think you can see that this has really been a process of a lot of communication and a lot of dialogue. I think the law demands nothing less. We want to get this right. And again, I appreciate all of your input and your input here today. Because of some input we'd already received to date, we announced about a week ago that we were going to provide a safe harbor until the end of the year for all employers that already provide their employees with the right to use at least a certain amount of time, paid time off. It's very important to me that we take account of that because we're not trying to overly complicate things. So we were clear that we did not support delay of the law, that this is a law that the voters passed, and it's our responsibility to work to get regulations in order that makes sense, but it's also to do it in a way that makes sense, and recognizing that a lot of employers out there already provide a form of paid leave, that we're going to give them additional time till the end of this year to update their policies, payroll systems, and the like. And I'm proud that that move was supported both by the Associated Industries of Massachusetts as well as the Raise Up Massachusetts campaign, which led the successful effort to pass this law. Now, with that rule in place, and it is a regulation, we can move forward and focus attention on the nearly 1 million of our most vulnerable workers in this state who will now stand to benefit and have been waiting since Election Day in November to have access to sick leave for the very first time. These workers will now have the ability to take a few hours off from work if they have a sick child at home or an elderly parent who's sick at home, or if they themselves are sick without fear of losing their jobs. This is important. one of the last listening sessions that I attended, we heard testimony from a personal care attendant in Boston who cares for an elderly woman who's in poor health. She also cares for her mother and her young child. When she's sick, there's simply no good option. She can risk the health of her employer or the well-being of her family, and that is a choice we do not think people in this time, in this country, and in our state should have to make. And these are the stories that we hear every day, the stories of people who have had to make that choice for far too long. And so the law is passed. We are here to implement. We are here to enforce. But importantly, we're here to listen to all of you today. And the listening and the discussion isn't going to end come July 1st. We've committed to making sure that through the efforts of people up here and throughout the office, we're going to continue sessions. I view it as our responsibility to educate, to do outreach, to assist in implementation, to work with businesses and employers to get things in place, and to make sure that workers understand their new rights and protections. So that will continue. We'll continue to update our website with new materials and information, importantly in different languages, that are responsive to the questions that we hear. And we've assigned staff from our office to carefully monitor and respond to those questions and to give employers and their counsel the support and the information that they need. I know that there are still concerns about enforcement, particularly while questions remain and the law is new. I want you to understand, though, that my view is we need to spend and focus attention on outreach and education, and I am confident that we will get there. All employers will be able to get there, and we're here to work for you. Employers who are working hard to follow the law and get up to speed and doing their job are not going to be the target of enforcement. We are here to work with you. But I do want to close by acknowledging that this law is expansive. It's the most expansive in the country. I understand that. I also understand that in Massachusetts we have a history of leading. And this fundamentally is about dignity and respect for workers in the workplace. I also know that employers across the state want to do right by their employees and work hard every day to make that happen. I also understand that employers are living themselves at the margins. I understand. And we're mindful of that, and we're here today to hear from you and take the steps necessary in the remaining weeks as we work towards final publication of regulations to get this right. So thank you for being here today. The voters made a statement about Massachusetts values. We believe in that. I'm proud to have voted for this law. I'm proud to have the opportunity to work with everybody on its implementation. And again, I thank you for participating in this really important process. And with that, we'll get started. Thank you.
Barbara Pillar-Sick. Good morning.
Thank you very much for giving me the opportunity to testify. My name is Barbara Pillar-Sick, and I'm the Executive Director of the Association for Community Living, and we're headquartered here in Springfield, Massachusetts. As a provider, I respect the time and preparation that went into creating these draft regulations, and I thank you for holding listening sessions and public hearings to gather additional information before you implement the law. I understand you visited 11 cities and have held numerous listening sessions and public hearings, and that is unprecedented as far as I know. We know that drafting these regulations within the allotted time frame has been a challenging endeavor. The Association for Community Living is a private nonprofit organization providing services to individuals with developmental disabilities and support for their families. We were started by 5 mothers in 1952 who believed that their children with developmental disabilities not only belonged with their families, but deserved services in order to be an integral part of the communities in which they lived. From the beginnings of community clinical nursery schools in the basement of churches, we are now an organization that provides services to over 700 individuals and 800 families in the 4 western counties. Today, we have an annual budget of nearly $28 million and provide 24-hour residential services, shared living, day and employment supports to over 700 individuals and 800 families. We also have the Regional Autism Center and provide day and employment services. Our nearly 600 employees are part of the 145,000 human service workers that represent 5% of the total workforce in Massachusetts. We are part of the economic fabric of the western part of the state where our employees live, pay taxes, and buy from local merchants and companies. We are proud of what our founding mothers were able to accomplish, often against great odds and social isolation. We are equally proud of the national prominence that Massachusetts holds in the field of developmental disabilities and know that our Commonwealth values the lives of our people and recognizes the hard work of our staff. We overwhelmingly support the rights of our workers to have access to paid sick time in a fair and reasonable arrangement. And I want to emphasize that. We overwhelmingly support this law. The work they do is challenging, and they deserve and need time off to tend to their own needs and those of their family members. We support the Earned Sick Time law and are pleased that the state is ensuring that all workers will receive these benefits. As with any changes of this magnitude, there are concerns that require resolution to avoid unforeseen and unintended consequences. And I will classify these concerns into 3 areas: organizational, implementation, and costs. Operational. In addition to confusion regarding sick time accrual and several definitions in the proposed regulations, which I will outline, we have major concerns regarding earned sick time use by relief and per diem staff. Implementation. The implementation of July 1st, 2015 remains problematic for us, given the amount of changes we are required to make to our payroll systems, develop and implement new policies, train staff on the application of our policy, educate employees, and ensure compliance. The safe harbor provision does not provide relief to our organization, even though we provide sick leave far in excess of what this law requires. Costs. The government mandate will result in increased costs to our budget, both in the additional sick time that we will need to pay out, coverage of other staff for the absent employee, and the additional management costs of tracking and ensuring compliance. As it is currently unfunded, we believe that we should be reimbursed for these additional costs in our state contracts. As a point of reference for my testimony, let me describe to you our current sick leave benefits. All of our full and part-time employees accrue sick time on a prorated basis of 6 sick days per year based upon an 8-hour day or 40 hours a week. So an employee who works 25 hours a week would accrue sick time equal to 30 hours a year. A 40-hour week employee would accrue 40 hours of sick time in a year. However, they may accrue up to 5 weeks of paid leave or 200 hours. Further, we don't limit the number of hours an employee may use in a year, so long as their sick time has a sufficient balance in it. They could use all of the 500 hours in there, all of the 200 hours in that year, all of the 5 weeks. Once the employee reaches the 5-week mark, they do not accrue any more sick leave, but they are allowed to carry this sick leave over from year to year. Sick time may be used for the employee, any family member, or anyone living in their household. We currently have 363 full-time and part-time employees who are accruing sick time under these provisions. We have 210 relief or per diem employees who do not earn any sick time. Many of these employees work only 4 to 6 hours a week and do so only if they are willing to come into work when called. They are under no obligation to report to work when requested. Operational concerns. We are concerned about the carryover provision of the 40 hours of earned sick time in that, based on remarks at the Salem listening session of May 11th, it appears that an employee may not accrue any additional time beyond the 40 hours if it is used at the beginning of the calendar year. This appears to be true even if the employee had not used any sick time in previous years. Our suggestion is that they be allowed to accrue sick time after using some, but never have a balance that exceeds 40 hours. Other concerns with the proposed regulations are, in Section 33.05, it states that an employee, when using earned sick time, shall, quote, make a good faith effort to provide notice of this need to the employer, end quote. The regulations do not define this or provide examples. In Section 33.05, an employee must report unforeseeable sick time, quote, as soon as it is practical, unquote. The regulations do not define this, and it could become contentious. In Section 33.05, it states, quote, an employer may discipline the employee for misuse of sick time, end quote. Is this defined only by the discipline in Section 33.06 that states, quote, the employer may delay or deny the future of accrued earned sick time by the employee until the documentation is provided, end quote, or may other discipline be imposed as this situation may warrant. In Section 33.06, it states employers may require a doctor's note after an absence of more than 24 consecutive work hours. For part-time employees working shifts of 4 hours a week, they would need to miss 6 days of work before an employer could ask for a doctor's note. How should organizations verify this? How will we cover our 24-hour shifts in group homes if we cannot predict when an employee will be able to return to work? The individuals we serve have challenging medical or behavioral concerns, and the staff who work with them are highly trained and cannot be swapped around from house to house without concerns for inadequate preparation to do their job. In Section 33.06, employees are allowed to provide, quote, provide a signed written statement evidencing the need for the use of earned sick time, end quote, in lieu of a doctor's note. How will we verify this? We have significant concerns about the operational impact on our ability to staff our services with qualified, competent staff if relief and per diem employees are able to accrue and use sick time. Relief staff may independently select whether to work or not at their discretion when they are called to fill a shift for a regular employee who is called in sick. If they are called and they are sick, they may simply decline to take the shift, and they are not penalized for this, nor they do not have any loss of income as they were never scheduled to work. We are unclear how they may use their sick time benefit, and this is problematic for us. If a relief employee is called to fill a shift, can they accept the shift and then immediately inform the supervisor they are sick? I'm glad to see you shaking your head. How can providers adequately budget for sick time earned by relief staff when they are called in to take the place of regular employees who are on vacation or out sick? The inclusion of these employees will create logistical and administrative hardships for our organization as we try to fill our shifts and ensure that our vulnerable individuals receive quality services from competent and skilled workers. A potential solution to this problem exists in Connecticut. The law in Connecticut specifically excludes a quote, day or temporary worker, end quote, which it defines as, quote, an individual who performs work for another on a per diem basis, or B, an occasional or regular basis for only the time required to complete the work, end quote. The important exclusion created by Connecticut would eliminate one of our major concerns with the proposed regulation. Now to implementation concerns. We respectfully request that you postpone the July 1st implementation of the law, a mere 22 working days away. We are in favor of the law, as I have said, and in fact offer our employees sick leave benefits beyond the law's requirement. But, for example, in the following 22 days, these events will need to occur. We must reconfigure our payroll and IT systems for the new accruals. This will affect 210 per diem employees who work an average of 4 hours per week. We are not their first employer. Staff from IT, payroll, finance, and human resources must oversee and test the changes to the IT systems. Staff must spend time rewriting policies and procedures and train staff on their implementation. We have over 80 managers who must be trained on the proper implementation of these regulations. So I respectfully request that the regulations be postponed to January 1st, 2016. And then finally, our cost concerns. The additional cost of providing this earned sick time to our 210 per diem employees should be reimbursed by the state. This is an additional expense for which we have no income. These costs will need to be calculated and added to our annual renewal of state contracts, most of which have already been renewed for FY16. There are also unknown costs to reconfiguring our payroll and finance systems, to test those systems, to audit them on a regular basis, rewrite our policies and procedures, and train our staff on the new regulation. We will need to provide staff training on an ongoing basis as our employees turn over. In closing, however, let me thank you for providing this opportunity to testify on the impact that the proposed regulations will have on our organization. We, again, support wholeheartedly the provision of earned sick leave for our employees, and we have provided sick leave for our employees for at least as long as I have worked at the association, which will be 30 years this August. Thank you again for your attention. I'm happy to answer any questions you might have.
Thank you.
Thank you.
What's that?
Thank you very much for your testimony. And I meant to mention earlier, if you have written testimony that you would like to submit in lieu of testifying today, feel free to do so. There's a table out front with various materials, including a copy of the draft regulations, the safe harbor, etc. And you can leave it with our staff out there. That will become part of the official record as well. So next, Jason Trotta, please. I also ask if you could kindly keep remarks to 3 minutes, and if you have need to submit further testimony beyond what you are able to testify to and don't have it in writing today, feel free to submit it. We're taking testimony and any kind of submissions with respect to the regulations until June 10th. Thank you very much.
Okay. Hi, everyone. Hi. How are you? My name is Jason Trotta. I address you today both as the Executive Director of the Northampton Community Music Center and as Chairperson for the Northeast Chapter of the National Guild for Community Arts Education. We represent 57 nonprofit organizations, arts education institutions across New England, 32 of which are community music schools operating in the Commonwealth of Massachusetts. I'm here with Mary Ellen Miller, who's the Director of Faculty at the Community Music School of Springfield and is a clarinet teacher at our center. On behalf of my colleagues...
Anything, Jason?
I'm sorry?
Do you play anything?
I'm a composer and arranger. On behalf of my colleagues present in this room and who have added their organization's names to the piece of paper that I'm going to submit, we'd like to express our support for this and all legislation that endeavors to offer fair treatment to artists and arts educators who piece together their livelihoods as both freelancers and part-time employees at organizations such as ours. There are idiosyncrasies in how community music schools operate in relationship to its faculty and its students that is not fully considered in the new earned sick time law as it currently reads. Each year, music teachers enter into agreements with community music schools, availing themselves to teach music lessons during specific days and time frames of their choosing. The school then matches students with teachers based on the instrument or subject the student wants to learn and the mutual availability of the teacher and the student. The school collects lesson fees from the students and then subsequently pays the teachers out of those fees. Students are required to pay for all scheduled lessons, whether they're present for those lessons or not, protecting teachers from not getting paid when students don't show up. However, when teachers must be absent, community music schools rely on those teachers to make up those lessons at a later date so that the student gets the service they've paid for. Section E of the proposed earned sick time law seems to allow this type of agreement with the understanding that the services will be made up within 2 pay periods of the employee's absence. However, teachers and students have traditionally relied on much more flexibility than this, often having to wait until a school break or at the end of an academic term to find a make-up time that works for both parties. We respectfully request a regulation to the new earned sick time law that allows organizations like ours to enter into agreements with our teachers that ensures payment to them when they're sick for whatever hours they were scheduled to work that day, but with the understanding that they'll make up those lessons with their students within a reasonable time and mutually beneficial time that extends beyond the current 2-pay period restriction. I thank you for your time and consideration, and if you have any questions, we're definitely a unique animal, the way we operate, so.
Thank you. We're evaluating, and it is our intention in the final regulations to provide additional flexibility where employee arrangements, call for a delivery of services, oftentimes with more flexible schedules. So, and you'll be glad to know that music teachers, along with fee-for-service medical providers and many other professionals, share this sort of somewhat idiosyncratic aspect to their work. So It's something we're hearing from a lot of different industries, and we're working to make sure that you're accommodated.
Okay, that's great to hear. Are there any other questions for us? We've, again, fully support what you're doing. We really do. And we've made an effort as arts organizations to provide above and beyond what the law requires for our faculty. We have simpler IRA programs for our part-time teachers and all sorts of things. Over time, we've worked it out sort of organically, so it's hard. It's hard otherwise to make things all of a sudden work differently. So, thank you for hearing that.
Thank you. Thank you.
Tricia Canavan, please.
Thank you for being here today. I appreciate the opportunity to speak. I will keep my eye on my watch. I run United Personnel Services, which is a locally owned, woman-owned business. We've been in business for 31 years. My parents started this out of our house when I was a young child, and I've been in this role for 4 years. We have offices in Pittsfield, Northampton, and here in Springfield. We employ about 2,500 people annually, primarily serving the largest bulk of that are people who work in seasonal manufacturing roles. Back a generation ago, people might have been hired on just for the season and then laid off. We now provide that staffing support and human resources and workforce management to our clients. We have prided ourselves on being a good employer, including offering health insurance for our entire history, well before mandated by the ACA. We offer benefits like vacation pay, holiday pay, scholarships, 401k. So again, like some of the other organizations that have spoken before me, we are committed to our employees. I believe that sick leave is a human right. And I have to say, to be perfectly transparent, while we've offered it always to our 30 or so in-house staff, this is not something that we've offered to our contract employees. And frankly, I'm a little ashamed that it took legislation to get me to move on this issue. But I believe it's a human right. And I believe that if you're sick or if your children are sick, you should be able to stay home. However, and I would like to say I think the spirit of the law is excellent. I have some concerns about the implementation of the law and also the logistics. I would echo many of the things mentioned by the Association for Community Living. I'm not going to repeat some of those concerns, but some things that I would like to point out. One of my biggest concerns about this law is abuse of sick time. And I have concerns about employees who may utilize this time because of the lack of performance management options for employers, as well as the lack of documentation. I have real concerns for employees who will use this time in a way that it's not intended. And for my customers who depend upon me and my team to provide them with employees to meet their manufacturing and operational needs, it's going to be a real hardship. We work, as I said, with some of the largest manufacturers in the area, and when they do not have employees on the line shuts down. Some of these employers require our employees to have 10-panel drug screens and both state and federal background checks, which here in Massachusetts, that can take weeks. So for me to easily respond to last-minute needs for sick time without being able to control and performance manage if there's an issue, that's a real concern. Our industry in Massachusetts employs almost 60,000 contract employees annually, and like the music school, there are some peculiarities to our industry. I'd like to also suggest and echo some of the points presented by the Mass Staffing Association in terms of looking at changing the break-in service regulations to reflect those in the Affordable Care Act, as well as if someone is ending their job, whether their contract is done or whether they've chosen to move on to another position, that sick leave taken during that time period would not be something that should be paid. So again, thank you for the opportunity to testify, and I really hope that you will hear the difficulties that the logistical implementation in terms of attendance that's going to result from this law. I have no doubt that 90 to 95% of our staff will take the full 5 days offered to them, and there's no way that it's all going to be sick time. And that's really a big concern that I have. The costs and the logistics of implementation, again, as echoed by other speakers, is also a concern, but I think that that's something I'd really like to point out during this hearing. So thank you.
Thank you. Elizabeth Tulin.
Good morning. Thank you for convening these hearings across the state. I've tried to attend as many as possible because I am eager to learn and hear about the experiences of employers who really want to implement the law and comply. My name is Elizabeth Tulin. I'm a senior attorney at Greater Boston Legal Services, and my organization represented one of the groups that took the lead on securing the ballot initiative. And this was done in response to the overwhelming need of nearly 1 million workers in Massachusetts who daily face the risk of a loss of their job, their health, or their family members' health simply because they have to go to work and don't have job-protected sick time. In addition, something that doesn't come up often is that at these hearings is that this law also protects workers who are affected by domestic violence, the worker herself or her minor child. And again, the income replacement provided under the law is another important feature because we know from experience with the FMLA, which doesn't require paid leave, workers often decline to take leave because they simply can't afford to attend to medical issues, or in the case of domestic violence, those issues, if they don't get replacement wages. I've also want to emphasize that the workers who lack access to earned sick time are among the lowest wage earners in the Commonwealth of Massachusetts. Of the nearly 1 million who lack access, 600,000 of them are earning less than $35,000 a year. And they are in predominantly our gateway communities such as Springfield, New Bedford, Fall River, Pittsfield, communities that are hard hit. And we want to promote as much as possible job retention and continued earnings when illness strikes or domestic violence arises. What's really helpful, I find, in looking at these issues and considering what decisions are made about further changes to the proposed regulations, I was looking at what's happened in other jurisdictions that have adopted these measures. And while this is the most progressive sick time law statewide, there are jurisdictions, municipalities, that have adopted a very similar range of benefits. In fact, in San Francisco, some employers are required to give their employees up to 9 sick days a year. And what we've learned looking at those jurisdictions is what's the uptake rate? Even with 9 sick days, the average uptake annually is 3 days a year in San Francisco. The reason for that is that employees regard their sick time like an insurance policy. They don't want to use it up and find out that, for inappropriate reasons, and then find out when illness strikes, they don't have the time. So research done on the practices and experiences of employers in Massachusetts shows that the uptake rate is actually anticipated to be even lower, 2.5 days on average a year. And I just want to emphasize, too, that this is the experience primarily in the private sector, which is the sector where workers tend to lack this benefit. In the public sector, most workers have job-protected sick time of some kind, or they have some paid time off. Don't want to take up too much time because I know the room is full. A couple of points, though, in response to some of the things I've heard. I definitely appreciate and understand the need to look at abuse. The concern that we have about really muscular provisions around attendance policies that discourage workers from using sick time is that there will be retaliation, or workers simply won't use it, and the goal of the legislation will be frustrated as a result. When it comes to the per diem employees and workers who are holding down multiple jobs, I think what this bill raises is a question about whether or not there are important changes that need to be made in the workforce, whether or not it's possible, putting aside for the moment people who want just a part-time job, one part-time job, they only want to work maybe 4 hours a week, look at whether or not some of those per diem employees would actually appreciate a 20-hour-a-week job, maybe a 30-hour-a-week job, instead of patching together, 4 or 5 per diem jobs. When it comes to the relief workers, other jurisdictions have handled the relief worker situation by saying that a relief worker who accepts the assignment, wouldn't do it in the event of a foreseeable illness. Again, the concern is that if I am a relief worker and I'm on the job and I get a call about a sick family member, or I spike a fever, or I'm handling a vulnerable patient and I myself am sick. This happened to my niece who is studying nursing right now, and she was at the hospital working on the job, and she became so ill she had to go to the emergency room of that hospital. And to the credit of the Tufts Medical Center HR department and her supervisor, she was asked to go home. They understood. We don't want a sick person treating our patients. And I understand the abuse issues. I do think that managers have an opportunity to set performance goals, to evaluate employees, and have plenty of opportunities to assess their performance and decide, is this person performing on the job? The other thing is that I wonder what happens in the workplace right now without sick time when someone is sick and it poses a problem, for example, on a shift situation. And I'm just hoping that people who are really sick, who are, again, suffering from the effects of domestic violence, right now those situations, I imagine, are being handled maybe informally, and maybe they could look at how they're doing that now. Thank you.
Thank you very much. We're going to take one more and then take a break. Jennifer Duke.
Good morning. My name is Jennifer Duke. I'm an attorney and I practice employment law, and I have some questions regarding the primary place of business designation, and I want to thank you for holding these hearings, which I've been attending so far to learn more about the regulations. And my questions are a little more on the logistical side. So first, as far as determining an employee's primary place of business, I have clients who have employees over multiple states, and some transfer in and out of Massachusetts. So there have been a lot of questions about, in practice, how are we going to determine how to track the accrual or what happens to accrual as they come in and out. But the first basic question is, it's a little unclear as far as what time frame the employer looks at as far as determining the primary place of business. So if it's an employee who's been there for a while and they've been there an entire year, do we look back at their previous year and then that place of business designation sticks throughout the following year? Or is each new year a clean slate, and with the understanding that the employee might be transferring in and out of Massachusetts, so it's a little bit in flux, and so that's the basic premise of some of these questions. So if the designation is based on the employee's current year of work, and the employee might be transferring, if the primary place of business is originally in Massachusetts, but then then they end up working in a place where basically they lose that primary place of business because they end up transferring and working a longer time outside of Massachusetts. One question is, what happens to that accrual they were originally potentially going to have? Does this go in line with the break in service? So would the employee go into sleep mode for tracking time, or basically, because we don't know what period of looking at their employment, we're going to figure out the place of business. That's where the confusion lies. And then if an employee remains, excuse me, let me just see my note here. Actually, I think that's all I have for now, but you said there was a question and answer session later. Is that the type of...
It's not a session per se, but anyone who has
okay.
questions can remain here, and we'd be happy to talk through.
Okay, that would be
issues
more
and
of a
questions.
dialogue. Okay.
Yeah.
Thank you. Yes.
Jennifer, right?
Jennifer. Mhm.
Jennifer, the current regulations states that, to begin with, the statute reads that all employees who work in the Commonwealth are eligible to accrue and use earned sick time. So in attempting to define what is an employee who works in the Commonwealth, the current regulation, as you've stated, says that it'll be determined by whether or not the Commonwealth is their primary place of work.
Mm-hmm.
For the vast majority of employees, their primary state of work is relatively clear. So in this case, we'd be very interested to know, for the relatively small number of employees for whom this is confusing to employers, we're open to recommendations. It may in fact be easier to determine based on looking to the previous year.
Mm-hmm.
It may be easier to determine it based on the current year. But the intent is not to have somebody moving on and off of accrual, as they take a temporary status job in another state or one assignment that's elsewhere, because the intent is to have them accrue on that job if their primary place of work is in the Commonwealth, if that makes sense. But we would be very interested to hear a recommendation on that subject.
Okay. Thank you.
Okay. Thank you very much. I believe we're going to take a break now for about 5 minutes, and we will reconvene. And right now it is 11:26. We'll reconvene a little bit after 11:30. Thank you very much. Okay, it is 11:40 a.m. and we are back on the record. If I could kindly call Tammy Hall, and I believe the panel that is accompanying her, Lesbia Vidot, Michelle Jordan. And if you could, before you start speaking, since you're a panel, please identify yourselves and just in the order in which you're speaking. Thanks.
Good morning. My name is Tammy Haw.
Morning.
And I am a PCA of Springfield, Massachusetts. And earned sick time means a lot to us right now. When I was a CNA for 30 years, I had all the benefits. Now I am a personal care attendant, and I care for somebody at home. I have no benefits. I have had major surgery 3 times, and I have lost my first major job as a PCA because I had no benefits. So earned sick time means a lot right now, and we just need to find a way to work this in so that we are all satisfied being able to take the time off that you need. A lot of people are going through so many things, having these surgeries, not being able to pay their bills, and when you get sick and you have to stay home, that's an income that's lost right there, especially for us as PCAs who live on that one income. And right now, it's, we've done this November 4th. We've talked to people. We've been all over the community. We've got this on the ballot. Now we have only 22 days to get this done right. People are waiting. Down the line, I have a prior surgery coming. I have one consumer, and I'd like to be able to be covered. I would like to be able to keep my bills paid without losing something. Because when that happened to me the first time, I lost a roof over my head. I had to go apply for benefits from state welfare. I don't want to live on welfare for the rest of my life. I am 52 years old. I want to be able to be out there to work, but I also want to have the benefits I need to take care of everything that needs to be done while I'm healing. That's it.
Thank you.
You're welcome.
Hi, my name is Michelle Jordan. I'm a PCA. Along with Tammy, I've had previously a procedure, and I couldn't take time off from work, so after the procedure, I went to work. I can't afford to take time off because I don't have sick time. So if I don't work, my children don't eat, and I don't have a roof over our heads. So we need this done. We need this to be implemented as soon as possible. We want to be taken care of, just like the other types of people that work in different industries. So we take care of people, elderly people, and people that are disabled. And as much as they need us to be healthy and there on time, we need to have this done, this earned sick time implemented as soon as possible. So we support it. Thank you.
Hi, my name is Lesbia Vidot. I'm also a PCA, personal care assistant in Massachusetts. I live in Holyoke. I got a 10-year-old son. I got to put the food on my table, simple as that. If I don't work, if I'm sick, I take the risk to my consumer gets sick too. And that send my consumer to hospital. That's another issue. We don't got, if he's in the hospital, I don't get paid. So I need desperate to put food on my table, to pay my bills, to pay my rent. I don't want to be on welfare, and I'm sure that it's unfair for not only for me, for the 32,000 PCAs in Massachusetts. Thank you.
Thank you all.
Thank you.
John Weissman.
Hello, thank you for the opportunity.
Thank you.
My name is John Weissman. I'm accompanied by Obrisha Windy Edick. Just for moral support, Wendy is requesting not to testify, though she has quite a lot of stories. She worked at Walmart for about over a dozen years, organizing workers there, and eventually that got her in trouble, got her fired. I work for Jobs with Justice. That's the Western Mass Coalition is about 80 organizations that are a mixed group of unions, community groups, religious and student groups devoted to workers' rights. It's a national network of these coalitions, about 44 across the country. And we work very closely with Wendy's organization, OUR Walmart, organization United for Respect at Walmart. I worked at the post office for 32 years. I was president of my union, the National Association of Letter Carriers, Branch 46 for 12. And both of us have had the experience of working for the two largest employers, actually, in the country, the largest governmental employer, the largest private sector employer, both of whom provide sick time policies and programs, and both of them have, we've had a wealth of experience dealing with all those issues of abuse and the countercharge of defending workers who have been accused of abuse. I'll come back to that. I wanted to emphasize today, though, that this is a health and safety law. The history of health and safety legislation in the United States is one of delay. Typically, we pass our health and safety laws after millions of people have suffered the consequences of not having them, including death. There's no reason to delay in this case that I've heard yet. I'm glad to have had the opportunity to listen to other people speak, but delay is not to be on the, from where we sit. We are also members, by the way, of Raise Up Massachusetts, the coalition that helped pass this law. We are not in a position to say in any way to justify delay. We are faced with a situation right now today where nearly 1 million hardworking Massachusetts residents, citizens, and workers, almost a third of them that work in the state, almost a third of our workforce, can't take a single paid sick day or risk, and they risk losing their job if they call out. So anyone who's asking for delay is asking for the ability to sustain a situation which is basically retaliation against what one eloquent speaker called the right to sick leave. So it would be unconscionable to allow both the health and safety effects of not having this law and the retaliation effects of not having this law be delayed. They've already been delayed when you think about it. We've already delayed taking care of this problem for how many years? So please don't delay. No matter how you handle the July 1 date, in particular cases, there should be nothing in what you do that permits retaliation. So we could easily go into a situation where we have no, maybe something, maybe the electricity is turned off for a month at your office and you can't produce your regulations. We still should have an edict on July 1st, there shall be no retaliation for people who call out sick, period. So that was one issue. Then there's the issue of contingent workers. Contingent workers are becoming too normal. I'm asking that anything that you do to address the issues of employers of temporary, part-time, per diem, or whatever, workers not incentivize the creation of these jobs. We should incentivize, which is one of the projects we have both at the post office and at Walmart, incentivize the cobbling together of work to create steady, regular, full-time jobs, or at least the number of hours that an individual worker wants. So that's the agenda item. It's not to delay in such a way as to figure out a regulation that will somehow accommodate more and more contingent workers. We do not want to incentivize unwanted contingent labor, no matter how many people need part-time jobs, which we recognize. Thirdly, we have a wealth of experience in dealing with this question, which one speaker called performance management. Regulation like this is, my understanding is that you're not going to be asked to address the question of abuse, sick leave abuse, and shouldn't. However, what if you did? Then the counterbalance is to include just cause and due process. So, at the Postal Service, and even at Walmart, there are steps through which you go if you are accused of sick leave abuse to try to say, no, I did not abuse my sick leave, and prove your case. Of course, in a union environment like the Postal Service, you have an advocate who can take it all the way to arbitration. At Walmart, it's a very one-sided process. But if you were to allow yourselves to address sick leave abuse in implementing this law, I think you have to counterbalance it with the defense of the accusation of abuse. And you'd have to give us, all workers in Massachusetts deserve it anyway, due process and just cause for discipline. Thank you.
Thank you very much. Thank you, Wendy.
Just to comment on the last point, there's been many comments submitted in writing and calls to our office just with questions about the relationship between the good faith notice requirements to take leave, the permissibility of requiring post-use verification by employees, and then the documentation provisions. Several of the speakers have raised questions about sort of how these sets of rules kind of work together. And our aim, and you heard this from the Attorney General, is a workable balance that allows employers to extend this, allows employees to avail themselves of this benefit for proper uses without feeling that they're in an environment where, in fact, they're not supposed to take the benefit for allowable purposes, while ensuring simultaneously that employers have appropriate and reasonable means of policing incidents of abuse. And that is sort of the balance that it's our job to strike, and we certainly appreciate everybody's helpful comments in helping us get there. So that's just a bit of an editorialization on our working process. Thank you.
Okay. Deli Williams. Liz Friedman.
Thank you very much for hearing me. Again, I'm Liz Friedman. I'm the program director of an organization called Mother Woman. We are based in Hadley, Massachusetts. We support and empower mothers to create positive personal and social change for ourselves, our families, our communities, and the state. And I am sitting here with Kathy Manley. We have been working on earned paid sick time for the last 6 years as part of our legislative advocacy work on behalf of mothers and their families in Western Massachusetts, in Berkshire, Hampshire, Franklin, and Hampden counties. Through that effort, we then joined with Raise Up Massachusetts, and we were one of the more than 100 community organizations, religious groups, and labor unions that made up the coalition. We have heard stories directly from our mothers and their families for many years. I just want to quickly tell you a story from our Pioneer Valley, from Amherst. A mom by the name of Rin, who was working at a local coffee shop. She was a very dedicated worker. She had an infant under 12 months of age who was staying with a neighbor because that's what she could afford to do for childcare on her minimum wage job. Her son became very ill, and she still went to work, and she left the baby with the neighbor because she didn't have any time off, and she needed to make ends meet and get food on the table and keep their apartment. On the second day, she went to work again. The baby was still very sick. On the third day, she really had to take this infant to the doctor, and it was imperative. She called her supervisor at that point, the manager of the coffee shop, and shared that with him. And he said, "That's fine. take your child to the doctor, and by the way, you are fired. And this is a story that we have repeatedly heard by parents who are in the impossible situation of trying to take care of their children who they love and who need and deserve health care, and the jobs that they must keep in order to provide for their children and keep their homes and their security. This also poses significant health risks in schools, in daycare centers, and other environments where parents are incentivized, because they have no paid sick leave, to send children to school sick. And there are serious consequences for all of us when children are then going school to sick. We have had, obviously, some major healthcare crises or illness crises in the last number of years as we've been fighting for earned paid sick time. I appreciate very much the comments of many who have spoken today with their concerns, especially as it impacts their business and the way that they practice their policies. But respectfully, I argue that families cannot wait, and that children are sick and parents are having to make impossible decisions that put them and their children at risk every single day, and we really must implement this as soon as possible.
Thank you very much. Just a point of clarity. There had been a lot of talk about delay in the legislature for a while and delaying the implementation date. And the legislature has voted on that and declined to extend the implementation date. So I just wanted to make sure that it was understood that that date is not currently under debate, and that the implementation will begin on July 1st as the law instructed it to be. And with respect to that, there is a safe harbor provision that applies to companies that already have sick time in place, and in order to take advantage of that safe harbor provision, those who have sick time must ensure that it's covering all employees. Some employers have a bifurcated system whereby full-time employees have sick time and not part-time, et cetera, and just be aware that there is that safe harbor provision, and it's, as the Attorney General mentioned, part of the regulations at this point.
Yeah. Just to expand on that point, so just two things. The law, as passed by the voters in November, says the Earned Sick Time law becomes effective July 1st. So no change has been made, and you've heard from many people opposing delay or requesting an accommodation, but the law is going into effect July 1st. So that's one of the reasons we're engaged in this listening session, and we're looking to get the regulations finalized. The safe harbor provision, which is Jocelyn just mentioned, we will be providing additional clarity for employers that have some paid time off for at least some employees, to figure out if they how they might go about availing themselves of the safe harbor for the 6 months between July 1st and December 31st. And this is a little technical, but I know this is a wonky crowd. So what we're asking is, if you have essentially what we'll be clarifying is that workers not currently given access to paid time off must be put onto an accrual schedule for sick leave that is consistent with the policies that you currently make available to those employees for whom you do make sick time available. So that'll be a choice that you can make if that's attractive to you for this 6-month period. Otherwise, for those employees, you'll need to start complying with the specific provisions of the law. So for some, that's a workable alternative. For some, that's not going to be as attractive as compliance. And for those who have questions, and I'm seeing some heads, we're happy to sort of take those. There's a little more complexity to it. But the law is going into effect July 1st.
And just to underscore one point, Mr. Weissman had noted, had emphasized that non-retaliation, the importance of the non-retaliation provision. All other components of the law, including the non-interference, non-retaliation, are in effect as of July 1st. So to be clear, with respect to all employers that to whom the law applies. Right?
Well, the non-retaliation provisions are.
Right.
But just those.
What? Right, but that's what it.
So, yes,
right,
but that's a very good point. Was there a specific reaction? Did you to the comment I just made? Did you want? I mean, we can talk later. I saw. Okay. All right. Sorry.
Okay,
Back to the schedule.
Okay. Let's see. Janet Callahan. She left. Let's see. Kimberly Klimkauk.
Hello. My name is Kimberly Klimzuk. I'm an attorney with Scholar, Abbott, and Presser. We're based here in Springfield, Massachusetts. We are a firm that represents employers in all aspects of labor and employment law. So part of my goal, I'm certainly not here to advocate for or against any part of the law. I understand what the law is, but I've had a lot of questions from clients basically wanting to be in compliance, but because of some of the ambiguities in the law and even in the proposed regulations, feel that they can't quite do that. So my goal is to raise some of those ambiguities today, bring them to your attention. They may have been brought to your attention previously, but hopefully this will be another data point for your use.
Thank you.
Great.
So one of the issues is right at the beginning of the regulations, which state that with the interaction with state and federal leave laws.
We'll be clarifying in the final regulations that earned sick time may run concurrently with Federal Medical Leave Act use. So,
all right, perfect. That takes care of that question. All right, another concern that some clients have had is with the issue of front-loading time and the carryover of time. Mm-hmm. So for employers that front-load time, there's not really any purpose of the carryover, and we just wanted to make clear that they don't have to do both. I mean, they can do that, but if they're saying that somebody can carry over time and they're front-loading, it doesn't really serve any purpose.
So long as the front load at the beginning of each benefit year is 40 hours, then there's no then rollover is not required, and actually accrual is not required because they're already having access to the sort of the total amount of time that they could accrue over the course of a calendar year.
Okay, so maybe just something in the final regs to make, because I think that is clear with the accrual piece, but I think it's not quite clear with the carryover provision.
Right, and that's assuming that the 40 is renewed at the beginning of each year.
Correct.
So yes.
Correct. Okay, so then the next issue is, I understand that certification of need for leave can only be required after 24 hours of consecutively scheduled work hours of absence. However, a lot of employers do require a fitness for duty certification to return, so it's not really certifying the need for leave, but certifying that somebody is able to return to work because of the nature of their work, where 3 days of absence might suggest that they might be unfit to return. So that, that the regs don't speak to that, whether that's acceptable, and I think the regs do mention something about not requesting additional certification, so I didn't know if that would be anything that would be clarified.
Can I ask you, this is an area where perhaps you can educate us. Under what conditions may I, as an employer, require a certification that I am safe to return to work? Can I just choose to have that as part of my policy, or are there specific industries or workplace settings where that's allowable?
Well, for example, if somebody does take FMLA leave, the FMLA specifically allows an employer to require fitness for duty upon return. So even if somebody were to take a 3-day FMLA, an employer under the FMLA could require certification, but might be prevented from doing that under the sick leave law.
But they're separate rights and laws. So we are going to clarify some of that exactly, just to parse it out so that it's clear what follows from this law.
Right, or even the Americans with Disabilities Act would allow you to make fitness for duty requirements in some situations as well.
What we're aiming to do is strike a balance here again in terms of workability. We want to make sure that employers are able, as is their responsibility and right to ensure safety in the workplace. What we can't do is create an end run around the documentation requirements so that anytime you availed yourself, let's say, of a couple hours of sick leave under the law, let's say to take a child to the doctor, you would then need to provide documentation from a medical provider that you were fit to return to work. So any suggestions from anyone in the audience that they'd like to submit about accommodating, reasonable policies to ensure safety and health in the workplace would be appreciated.
Okay. Yeah, and even in that situation where there's a fitness for duty certification, it really wouldn't say anything about whether the leave was taken, pursuant to sick leave. It would just say, yes, this person can work, basically. So it wouldn't affect whether an employer was trying to discipline or anything for use of sick leave. All right, so next topic will be on the issue of the same hourly rate, and there are just some questions I've had from clients that I couldn't fully answer based on the proposed regs. One was what to do with on-call employees. So on-call employees are employees who remain on call, but they're only paid if they are, this is maybe similar to the relief issue that was raised earlier, but they're only paid if they're called into work. So if somebody calls out sick saying, I can't be on call, how would you pay that person? Because normally on call, that person would only be paid if they're called to actually report to work. And here they're saying they can't report to work. Does that person stay on call? And then when you call them, they say, okay, I can't report. This is the same issue that the relief staff person raised earlier. Also, for tipped employees, my reading of the statute initially was that tipped employees would just be paid minimum wage, unless they have a higher right, the higher of minimum wage or their tipped rate. But I have had some clients concerned; they just want to make sure that they don't have to incorporate tips that would normally be earned in that. Okay, and then with respect to premium pay, it wasn't entirely clear if premium pay would include differential pay. So I didn't know if that would be clarified.
This is just to clarify for the group's purposes. This is, let's say, a night shift on the same job that is paid at a different rate. Is that what you mean?
Right. So somebody works second shift, so they get $1 more per hour than than the first shift person doing the same job would get.
Is it their regular? Do they work night shift all the time? I
Right.
guess is going to be the question.
Well, it could be either way. So it could be somebody who works the night shift all the time, so they always get, say, $16 an hour versus $15 an hour. Would that person just get their normal $16 rate? Although the regs say that premium pay wouldn't count, and often employers consider differential pay a premium pay because it's a premium paid to people who are willing to work the undesirable shifts. Or there could be a situation where somebody does work fluctuating shifts, and it just so happens that even though they work first shift, second shift interchangeably, it just so happens they call out on the second shift. And then would you discount that premium rate? Would it be subject to a blended rate calculation, or how would that operate?
Thank you.
Yep. And then I know other people have mentioned abuse, so I won't talk about it too much because I know there's a concern. I know that the majority of people will use the law use their leave as it's intended. Unfortunately, I do have clients who have they've had experience with abuse, whether it be FMLA, and they know that there are going to be those employees who do abuse sick leave law, and they want to know whether they can, what they can do to address those issues. And I know that basically the regulations mention if somebody is committing fraud or abuse, you can. Then you can, well, does it say you can discipline?
Yes.
Yeah, so you can discipline, but basically in two situations. One, if they use the sick leave for some reason and they're not actually either sick or taking someone to the doctor or domestic violence leave, they're out golfing as opposed to being sick. Or by exhibiting a clear pattern of taking leave on days when the employee is scheduled to perform duties perceived as undesirable. And I noticed that what was conspicuously absent in the regs is something like taking leave on days when it might suggest abuse. So, for example, I know people who have people on FMLA intermittent leave, suddenly their symptoms kind of flare up every Monday and Friday, and they want to know in a situation where somebody has 40 hours of sick leave where the employer can't require any documentation, somebody hypothetically could take off 1 hour early every Friday for 40 weeks of the year without the employer having any recourse.
It was the intention, we used language that's been helpful in other jurisdictions. It was the intention not to suggest only that sort of latrine cleaning duty was undesirable, that also perhaps working late in the afternoon on a Friday in the summer would be considered undesirable. But
well, that would be something we would suggest as a clarification in the final regs. Just to
can you speak perhaps just for a moment, since you've raised it as an employment attorney, about the mechanisms that employers have currently to, let's say, to sort of ensure accountability by their workforce and whether people are meeting standards of, workmanship that are not just tied to provisions we would write into the Earned Sick Time law? I mean, what are the current ways that you advise employers to track their employees for sort of whether they're doing their job well, whether they're a good employee?
Well, certainly everyone has performance standards, and if people aren't meeting them, they can discipline. I think some of the concern is what happens if a person isn't meeting their performance standards because they happen to take Friday off 20 weeks, or whatever it is, Friday afternoon off a certain number of days per year. Can they discipline for that failed performance, or is it going to be protected because the reason for the poor performance might be tied to sick leave purposes?
Is it your experience, just to help us explain, to help us learn, is it your experience that when there are performance weaknesses, let's say, or are so limited? In other words, if am I otherwise an exemplary employee except that I routinely illegally use a benefit for an improper purpose?
Often, I think that's not the case. I think often the employees who are suspected of abusing their time off often also have other deficiencies. And that creates a new challenge because if they try and address those deficiencies, then the employee comes back and says, well, you're really disciplining me because I used my sick leave or because I used my FMLA leave and not because I already had an issue with performance. So I don't expect that to be anything that you guys could address in the sick leave regs. It's just a fact of life for employers, unfortunately. But I'm sorry, I do want to raise, without taking up too much more time, the holiday pay issue. And I don't know if you've heard about this because a lot of employers have policies that say if you don't attend work before or after a holiday, then you won't receive your holiday pay. Are you planning on addressing that in the final regs?
We are considering language. The regulations currently state that bonuses paid to employees with exemplary attendance, for example, are not impermissible under the Earned Sick Time law. That's sort of like a bonus for always showing up.
That's how we see it. So, but do we now have to tell everyone they have to change their policy to say you don't get holiday pay, but as an attendance incentive bonus, you will get paid for your holiday if you show up the day before and the day after the holiday? It's effectively the same thing, just a matter of semantics, and we just wanted to make sure. It would be nice if the final regulations would specifically state that holiday pay policies are allowable, especially because, for example, this year Christmas was on a Thursday. So for employers who don't have that kind of policy, a lot of people call out Friday. They get Thursday, Friday, Saturday, Sunday off because they extend their weekend. For employers who have instituted practices that say you're not going to get paid for Christmas unless you show up the day before and day after, they've found the incidence of that sort of thing dropping significantly.
We're working on it.
All right. Okay. All right. Thank you.
Thanks very much.
And particular thanks for indulging a number of questions.
Right. Eileen Drum, please.
Going towards the end, everybody's kind of covered stuff, but I'll tell you, I'm Eileen Drum. I'm the executive director of the Greater Chicopee Chamber of Commerce. Kimberly's firm, Scholar, Abbott, and Presser PC, one of their attorneys has done 2 seminars for some of our chamber businesses to try to help them understand this new law prior to the proposed regulations and since the proposed regulations. As a former minister in the United Church of Christ, a hospice chaplain, a hospital chaplain who's worked with PCAs and CNAs, who was a member of Arise for Social Justice, I am all for the law and the spirit of the law. But I'm here today representing 376 businesses. And what I'm concerned about, what I'm hearing is we're going to do this, and the regs are going to say that, and when the final regs are done, It's May 29th. I've got 376 employers who need to be in compliance by July 1st when we don't even have any final regulations. And if they're not in compliance, they're going to get fined, and they're going to get fined again, and they're going to get fined again. So we're not going to delay the implementation of the law, but what kind of relief or grace period or something for employers? Because although the voters voted this in back in November, the employers are still stuck trying to put a new employee handbook into place, trying to update their policies. A lot of them are small businesses. Some are as big as Bay State Medical Center. They're going to get nailed. And they want to be in compliance. But they're freaking out, and that's what's happening.
So we think this is so, Eileen, allow us to, well, let me say this. You heard, if you were here at the time, around 10:40, from the state's chief law enforcement officer charged with enforcing the law and the fines that you referenced, right? Who said that that we consider this, the Attorney General's office, and my colleague Marconi, who's been pretty quiet, but is the Director of Community Engagement, we are here with a message that is, this is about education, this is about outreach. Our workplace laws only work when everybody understands them, and we know that the vast majority of employers are trying to do the right thing. Jocelyn, maybe you can speak to from the Fair Labor Division's perspective. We are specifically stating that nobody who's making an effort to comply with the law is going to be the target of enforcement, and that is our very, very strong message to the private bar as well.
Yeah, especially over the next, 6, 7, 8 months, our goal is going to be to make sure that employers learn to comply with this law and that they understand it and can work with it like it's secondhand, and that employees know what their rights are also, so that they can exercise them. The right is to not lose your job if you're sick, or what the rights are for employees. And with respect to the technical challenges that employers, I think, are most frustrated with, they need not be worried about enforcement actions coming down on them,
because they are, not to interrupt you, but
this
they
is
are.
Why we're passing this, making sure that you tell the 376 businesses in your charge that message that we really, this is a law that's not going away. The public has strongly supported this, and we want to make sure it works. And we're not interested in going after businesses with gotchas. We want to make sure everyone knows how to implement the law, how to comply with the law, and that employees know what their rights are, and they feel free to exercise their rights without the fear of losing their jobs, retaliation, someone getting sick, infecting the workplace. And so we really want you to see us as partners in bringing the education and the information to your chapter and to others across the state. That being said, things like retaliation, if someone mistakenly retaliates against someone and fires them, those are not going to be looked upon, happily. But that's not what you're talking about. You're talking about people trying to do the right thing.
They're really trying,
and we want to make sure that they know how to do the right thing. And if they have problems doing the right thing, they can. They might get brought to our attention. We will work with them to make sure they know how to do the right thing. Tell them that we are here to be their partners, and we're here to both protect the workers and to make sure that employers are protected in the sense of having all the information they need to do the right thing. And I think this ultimately, once it is smooth and becomes secondhand for everyone, it's going to be a great thing for both public health and for our economy ultimately. So we're not interested in little ticky-tacky violations and penalties. We're interested in helping compliance get underway.
Yeah, I thank you for that. Part of what has led up to this, I think, this sort of fear factor, is that in the past maybe 10 months, 11 months, we've had a new minimum wage and unemployment insurance. We've had a new domestic leave law. We've had a new parental leave law. We've got the ACA. all wonderful things for employers
Right.
and even for employees, but for employers to be in compliance and to try to get all of these procedures in place, it is a nightmare,
Right.
and they are really struggling.
Yeah, I mean, I think last year was probably the busiest year in with respect to workers' rights that the state has ever seen. A lot of those things were a long time coming, and they all just happened to happen. We appreciate that. We also, we also feel the weight of all that because we enforce a lot of that. So just know that we understand the business community's views on this. We recognize the difficulties, and we will continue to work with you and your members and other employers. But underscore that this ultimately is about protecting workers and rights and keeping people from losing their jobs and their homes and feeding their children and all that. I think we will make sure that this becomes something that works for everyone. And we really appreciate your coming here today, and all the other business owners and representatives who've come to help us make this better. The regulations better, more workable, and thank you.
Thank you.
Just want to add something. The Attorney General created recently a division, which I'm heading that division, called Community Engagement. So that means that this, regarding to earned sick time and many other issues, it won't stop, especially about earned sick time. It will not stop on July 1st. Okay, implementation, here you go, you have to comply. We are planning to go across the state to continue this quote-unquote educational work, both to employers and to employees regarding the earned sick time. So we are going to meet with employers, we are going to community centers to meet with employees, we are going to churches over the weekend, we're going to be everywhere in different languages to make sure that everyone understands the law. So it will not stop on June 30th. It will move. We're going to have a busy summer because the idea of the Attorney General is that this will be implemented smoothly and everyone really understands how the law is, how the law works. And so, in the end of the day, there is a compliance from both sides.
Okay, thank you.
Thank you. Yep, thank you. And not to belabor, but similarly, if you're interested in having somebody from the Attorney General's office come out at that point, we'd be very interested. Yeah. So.
Okay. Thank you very much.
Thank you. Okay. Kate Fellham?
She had to leave.
Oh, she did. Thanks very much. Martha Spiegelman. Martha Spiegelman?
Yep, she's right there.
Oh, okay. I'm sorry. Thanks. Okay.
Hello.
Good morning.
Thank you.
Good afternoon.
My name is Martha Spiegelman. I'm a resident of Amherst, Massachusetts. I'm not an employer. I'm not an employee. I'm in that fortunate position of being retired. And I worked with my husband and a large number of people on the Raise Up Massachusetts campaign. And I'm a little bit surprised that these hearings are the first that I know about these regulations, because the ballot initiative was passed almost 7 months ago, and it seems to me right now, hearing some of the discussion and some of the presentations, particularly by some of the employers, that many of them are in something of a quandary about what they're going to be doing in a little over a month from now when it comes time to begin this implementation. Now, you told me, so you've taken some of the wind out of my sails, you told me that there's not going to be any delay in implementation, that this will start on July 1st, 2015. So I'm glad to hear that, and I'm just, as I said, sorry that we haven't moved faster on this whole question. I want to bring up something a bit different. And I don't know whether this panel is equipped to talk about this, respond to it, or if there's going to be another panel. But cities and towns are able to opt into this earned paid sick time, but they don't have to. Now, I do live in Amherst, and our town is doing something about it, and the personnel board of our town is going to come up with a plan, and I think it will probably be a good plan after we do a lot of work on it with a lot of input from citizen groups, citizens in town. In Northampton, the city council has opted in directly by saying we're going to accept the provisions of the ballot initiative. So there's two different ways of handling this by cities or towns.
Correct.
So one question is, the regulations you're talking about now, how or will they apply to cities and towns that decide to have some kind of a earned paid sick time?
Okay. So there were two parts. Why don't we take the municipal employees piece first, so that everyone is aware. This law, sort of, although not uncommon, but relatively unusually, was passed on the ballot by the voters. And our state constitution prohibits measures that would change expenses for local communities from being passed on the ballot this way without the municipalities being able to take some affirmative step to accept the burden, the expense burden. So that's the reason.
I was just going to add, whether the law is passed by by a ballot measure or by the legislature, the same rule applies.
That's
Mike's explaining.
That's a good point. Also true for the for laws passed the traditional way. So that's why the exemption applies. A local community that takes the affirmative step of accepting the sort of earned sick time law itself will be subject to the law. The regulations are just are clarifications to the law. So in all respects, they need to comply. Local communities, in some cases, are adopting some form of paid leave, but wouldn't necessarily need to be subject to the law's specific provisions if they chose to do it that way.
Right.
But that's a little different than all other employers. So to take your other point about sort of where we are in the process, and we accept that. The law was passed on the ballot in November. The new Attorney General was sworn in late January. So we've been working very actively, really since that period, to solicit feedback and comments, and we held dozens of meetings prior to the drafting and public posting of the draft regulations. But a law of general applicability that applies essentially to all employees and all employers in Massachusetts sweeps in communities of workers and employers that are not, that for many of you are commonplace, but are not sort of operating on a traditional hourly rate, in a specific location, or they're not salaried. We've heard today about relief workers, about music teachers. We hear about adjunct faculty at local communities, our National Guardsmen, student employees who work on campuses. And these are the areas where most clarification is necessary. And that's what we're working to do during this notice and comment period, which began, in April.
I just have one more question finally.
Let me just add to what
Yes.
he's saying. I mean, I think to understand the beginning of this process after the Attorney General got sworn in, it has been really to try to get as much good information from the public, from employers and employees while we were drafting the regulations, to really inform the regulations, to understand the idiosyncratic ways of certain big industries and big companies and employees and the different, to really have informed regulations to put out to the public. So what you have here by way of our proposed regulations was the result of an enormous process of having meetings and calls and getting feedback, written feedback and not testimony, but position statements from all walks of public life in Massachusetts. So unlike other regs that are sometimes written just, sort of baldly, applying a statute, clarifying words. This was really intended to take the public's, to be reflective of the a lot of input from the public at the outset, which is an unusual step to take. So, just wanted to understand it's been a very long process and has been highly informed by the input we've gotten from business and workers representatives for many months now.
I have just one more question. When will these regulations be finally crafted and available to the public? When would I be able to, say, go to the Attorney General's office website and find these regulations?
The 19th of June.
Thank you.
Thank you for coming.
Thank you. Thank you.
I have nobody else listed here as testifying. Come on forward.
And please state your name for the purposes of the public hearing.
My name is Will Flanders. I'm an attorney practicing up in Shelburne Falls, Massachusetts. And so I have one thing I want to just honor what you've been doing to do a good job of making these regs make sense. And so it's I know what kind of how much work that is, and I appreciate you for doing that. I'm also appreciating the fact that this is not going to be postponed. I really think I appreciate the letter that the Attorney General sent to the Senate in May, and so I'm 100% in support of that letter. The one piece, as I went through the regs, there was a piece that stood out for me that has to do with my particular practice. I work with worker-owned businesses, and I don't see anything in there that deals with the issue of whether partners or members of LLCs are employees or not. Generally, my understanding is that LLC members are not treated as employees. But I have worked with a lot of people who do worker-owned businesses using LLCs, and that needs to be clarified. So, in terms of definition of employer and definition of employee. So those are issues that pop into my mind and come up regularly in my practice.
Mm-hmm. Can just for clarification, what kind of businesses are they that you work with?
It varies, all different kinds. Some manufacturers. I have a couple of clients that are large manufacturers, and so on. So that's the question.
There would be two reasons to clarify the status of a person affiliated with a business as an employee. One, for the purpose of determining the size of the employer, to determine whether or not the leave is paid or unpaid, and the second, to determine whether or not they themselves have the right to accrue and use sick leave.
Exactly.
Is the second piece, for these owners, whether they have the right to accrue and use sick leave of concern, or is it the first piece, whether they count towards the size of the employer?
I would say both, but
as owners, biggest, I guess what I'm wondering is,
yeah.
And when you say owner, is it a full partnership or full? There are some businesses where employees have 1% of the ownership, and the principal owner has 99%. Is it that kind of a scenario, or?
Could be any number of different ways that LLCs are structured.
Okay.
So it could be that kind of thing, or it could be, everybody has an equal share.
Are they just looking to the language of the statute currently and to the regulations currently? Are they on the payroll? These owner-employee persons?
Yeah, they're typically getting paid. But they're also owners.
But are they paid how are they currently treated under the existing laws, the tax laws, the wage and hour laws, the Affordable Care Act?
I think they're frequently treated as owners, regardless of how they're being paid. And I know, for example, they're not covered by workers' comp. They're not required to have workers' comp if they're owners. So.
And with respect to payroll, are they getting? Are they, when you say they're treated as owners, are they still getting paid by the company?
Yeah, they're being paid, and sometimes it's there's a term for it. I'm blanking on it. It's guaranteed payments. It's like an advance, essentially, towards a share of profits. But they're getting paid on a same basis as everybody else in terms of when they get paid.
Well, as initial just feedback, first off, we would be inclined, as reflected in the draft regulations, to treat owners who nevertheless appear on the payroll in some capacity to count as persons for determining the size of the employer. Right? Secondly, we would be concerned about otherwise low-wage worker owners who were not able to avail themselves of the benefits of the Earned Sick Time law because the arrangement by which they affiliated with the business enterprise was as an owner and rather than as an employee. So any feedback from you on language would be helpful, but we would be inclined to, traditionally understood owners of companies have a lot of flexibility to take leave that sort of thing. So we would want to make sure that for these workers, if they aren't otherwise afforded those kinds of flexibilities, that they have at least the opportunity to avail themselves of the time afforded under the Earned Sick Time law. Okay,
great.
Is that?
Yeah, I think your question it feels like there are many different potential scenarios that you could think about because it's a just worker owned can mean so many different things,
that's true.
And so we will always be looking at the law through the lens of fulfilling its purposes,
Sure.
and I guess. It would be. I don't. To my knowledge, I don't think we've had any other feedback with respect to worker-owned companies. So, if, to the extent that you might submit something in writing that gives some more specific scenarios to contemplate whether the regulations need to specifically address the situations, that would be very helpful.
Okay.
Okay.
Great.
Thank you very
Thank you.
much.
Time. I actually have some more things that I didn't raise before because we're short on time.
Okay, well, let's quickly say, is there anyone who would like to testify who did not sign up to testify? Okay. And you too, okay.
Hello, my name is Stacy Gilmore. I'm the VP of Human Resources for Quabbin Wire and Cable Company. We're located in Ware, Mass. We're a manufacturer running a continuous operation to produce very long lengths of insulated cable products. And so the nature of our operation is this continual process. We need to continually monitor these long runs to ensure that the equipment is functioning properly, that we're producing quality output. And if there is any error in a 250,000 length run, we have to scrap the whole thing, and that can be 2 million feet of products, component products that go into the scrap, 2 to 4 million feet that go into scrap barrels. So we need to have people present to monitor our equipment. And that is why, although we fully support and we offer up to 5 weeks of paid time off and personal days and all kinds of flexibility, our concern is for this abuse issue. So I'm really glad that you and appreciative that you are also focused on looking for input on the abuse issue. And one of the things that I think could contribute to it in our situation is the lack of a minimum increment of time, basically suggesting that whatever increment of time a payroll system will allow would suffice to control abuse. And so in our case, our experience is most people need at least an hour off to attend an appointment, run home and deal with a sick child. It takes about an hour. So as I understand the law, to say that, say, 11 minutes or 14 or 22 minutes could be, an employee could just say, oh, I needed that for sick time, would pose a problem, because that would be when an employee could leave, not be monitoring this process, and we could have a major quality issue during that time frame. Am I understanding that correctly, that there's no, if our payroll system pays in 11 minutes, we would have to allow 11 minutes of sick time with no justification?
Well, so under the scenario, I just want to be clear, because regardless of the time increment, I think what you're suggesting is a scenario where somebody kind of walks off the job to avail themselves of earned sick time.
Mm-hmm.
So that is impermissible use under the good faith notice requirement, unless they sort of drop, unless they, I can only imagine sort of an uncontrollable sort of unconsciousness on the factory floor, which, presumably there's some redundancies built into your oversight process, but it would not, it's not a permissible use of earned sick time to simply walk away from work.
Would it be permissible to arrive late to work 11 minutes and say, because I was sick, I had to be late today?
Presumably you'd know that you're being late, so you should be calling to say, I'm going to be late. Right.
So here's
so again, this question comes up a fair amount. We understanding that we tried to base our notification requirements on the rules that we understand are in place in most school districts. If you're a teacher, you have to call. If you know you're going to be out well in advance, you make that known to your personnel system, the front office, the principal, in advance. If you're sick when you wake up in the morning, you call in the morning in advance of when work starts. But simply showing up kind of 20 minutes late and then sort of after the fact announcing having made no effort to provide notice for a position where you were needed is not consistent with the sort of notice requirements and the regulations as currently drafted.
Similar to saying, I need to leave 22 minutes late, I'm feeling really sick, and again, it's the day before the holiday, or it's, the big game is in 20 minutes,
Well, again, we're trying to distinguish, it's two different issues. If they are sick and they need to leave work,
or they have another bona fide,
or they're,
but we can't.
But hold on. I think
if you don't know, that's
if they say I need to leave for a doctor's appointment, for example, that sounds like a foreseeable.
That does. No.
So, in which case, the rule suggests that they should be providing reasonable notice that is not sort of immediately before leaving. Right? If they take ill and need to leave, or they get a call from school, let's say, your child is very ill, then they need to be able to make use of that time.
And I favor that.
No, I know.
Absolutely favor it.
But when you say, but then it's because of the football game, or then it's because it's Friday, so there, I think the suggestion is that they're using the time impermissibly, and if there's a pattern that expresses abuse, you would have the right to discipline that employee as you do under current law, because you're currently providing a benefits package, I think, where you would have the right to discipline somebody for misuse of your existing benefits package.
Yeah.
Can I ask a question? So you said you provide 5 weeks of sick time already?
No, that would be vacation time that could be used for sick purposes.
But sort of same, it could be used for that. Is it the notion of calling in, coming in late and leaving early, that makes you think there will be abuse when you already provide all this sick time? All this time that people can use, is there no concern that they're improperly using it now? Why would there be a...
There is concern that they're improperly using it now, and that's why offering more time, I've had 30 years of experience to say that, many, many people use it responsibly, and that we're fine there. But other people, if they get time, they will just use it, use it in what I would consider not consideration for the business needs.
So, but if you're already affording them time, you don't have to provide additional time.
Correct.
Certainly are encouraged to, I'm sure, by a lot of people, but the law allows you to use that time.
Yeah, and in our case, we have to restructure all of those benefits because they don't meet the full requirements, of the accrual and so forth. But what I'm suggesting is it would be most helpful in our case to limit abuse by having a minimum of 1 hour increments. That most sick issues would take an hour if it was, would take either a full day or at the very least an hour. And that even if it only took 20 minutes, you needed to run to the daycare provider and get, your child situated or something and then come back to work, that it would be reasonable to charge an hour of sick time for that. And an hour just works very well administratively, and I think it's also reasonable. It gives people the time. So they may only need 27 minutes, but they would use an hour of this sick time.
Okay, thank you.
Thanks.
Okay, and the gentleman in the black.
Good afternoon.
Good afternoon.
My name is Nick Henshin. I'm with the YMCA of Greater Springfield and also representing the Massachusetts HR Alliance for YMCAs, representing 42 YMCAs and almost 8,000 towns.
Thank you.
So one of the items that we're looking at, and I do apologize that some of the prior speakers had brought it up, was the classification of sick time potentially as wages when it comes to gap and audit. One of the concerns we had when vacation law was changed and vacation was treated as wages, it's therefore a liability on your book. So whether you front load, whether you accrue, whether you use a same year accrual or next year accrual, it's carried over. To give you an idea, an organization of our size of about $12 million, that represents almost $500,000. This is a huge amount for us to get on a year-end audit and liability.
What exactly represents $500,000? I'm sorry, I missed that.
Any vacation that an employee has, there's a few options depending on your auditor and your type of business. But vacation, one of three things will show up on your books: either what wasn't used, what is predicted to be used, or what was used. And one of the items that we've encountered, we're going through our audit currently with Cohen Resnick, is the concern that this law as it's currently written would then, under GAAP, require us to carry the sick liability as well as the vacation liability. So one of the items that
do you mean because of the rollover and the break-in service provisions?
Correct.
Okay, and you mean in your auditing you'd be showing a certain amount of liability on your books or potential expense for a subsequent year? Is that what you're saying? Okay.
Correct.
And you don't have carryover for vacation time?
We typically do not have carryover for vacation time right now. One of the problems, or one of the suggestions we have to this is a clarification stating simply that, just like vacation clarifies and says these are wages, is saying that this sick time is not treated as earned wages for the employee. The other item that we kind of look at, thank you so much for...
Can I ask, can you speak to why regulations are necessary to clarify that something is not wages that is not wages?
Yes. So one of the items that we look at, particularly with our auditors, is what are the potential expenses as a nonprofit. And we're required to declare any of those known items. So currently, we do not have to declare sick time because it is not mandated. Right now, under GAAP, and what we've been informed by both Department of Labor federally and then the IRS recently, is that any sick time would indeed have to be counted because after July, it would be mandated. So regardless of any safe harbor provision, we're looking at now having to accrue a new expense, not just quote unquote, on the PTO side of an employee's account, but we're going to have to be accruing it on our financials.
How is payment of sick time?
Can we just ask for written comments?
What?
Can we just ask for written comments?
Yeah, right. Okay. I'm wondering if do you not pay people when they're not at work because they're sick right now?
We currently have a bifurcated system, so full-time staff do receive sick leave. Part-time staff between 20 and 25 hours do receive a prorated version of sick leave, and below that amount do not receive sick leave. Our average staff member has over 30 days of sick time. We have one of the best PTO policies in the state, and the Y has actually been able to go toe-to-toe with a number of municipalities.
So I'm not quite understanding why, how something changes from an actuarial accounting stance when you already have sick time?
At this point, because sick time is not mandated, it is a completely and wholly voluntary option that we provide to our employees. Mm-hmm. It is not treated as a mandated liability. With sick time now moving to a mandated liability, and we saw something very similar in Connecticut just over 5 years ago, that now can trickle onto your books depending on how it is you're awarding this particular sick time.
And let's suggest this has not come up before.
Okay.
And we don't see, at least right now, we're not hearing the comment to speak to the provision of the benefit. So if you have written comments that you'd like to submit, whether or not it can go in the regulation, there may be something we can do to assist organizations that would have this particular challenge.
Okay, thank you. Mm-hmm. One other quick question we did have, and it echoes earlier that return to work concept. The majority of our staff are over the age of 40. We provide terrifically benefits because we do try to target all age ranges and backgrounds for employment. One of the challenges we do have is among these group of employees are our CDL bus drivers, which under the Federal Motor Carrier Agency are currently required to get a fitness for duty upon any belief that they are not currently able to perform the job. Mm-hmm. Case in point, we had a situation where an employee's eyesight had deteriorated after being out for about a 4-week period for an illness. Mm-hmm. As a result, she was in an accident. Mm-hmm. That item there, and thankfully that was an accident coming in not with any of our children on board, but another hour and she would have had a bus full of 42 kids. And one of the items that would have allowed us to prevent this, when she would have come in, we would have been sending her for a fitness for duty to return. So just I wanted to echo the importance and the critical safety, particularly from a child protection point of view, that that piece kind of provides in. And, you know, as a community-based organization, the Y is a big supporter not only of minimum wage, but also of sick leave law and equal rights for both parents, so whether it's maternity or paternity leave. However, again, like so many other agencies, we are looking at kind of the application. And what does this do? We have departments that run on $5,000 in service over 500 people. So for us to have a several $1,000 hit or look at a $250,000 hit, if we see something similar on that liability on the books for a sick time, is concerning for us, especially after this year. Our regulation today, including minimum wage in particular, has cost us $380,000. So that's kind of a big hit for an organization of our size as we try to preserve our services in the community.
Did you just, with respect to minimum wage, I didn't quite get that. Did you say the increase has cost you that much?
Correct.
Just because you were paying below minimum wage before? I mean, like below the $9 before?
We were paying below the $9 for a large amount of our staff. In particular, about 80% of our staff are part-time. And we use, to help complement that workforce, we have over 760 volunteers. So many of our staff coming in were either not at that level, or we had to bump up the next level because under the Early Education and Childhood Protection Program, so EEC, one of the things we were required was to have a certain spread of our minimum wage. So we also did see an increase on that side, which were some of our higher paid professionals.
Mm-hmm.
We have about 100 teachers on staff.
Okay. Thank you very much.
Thank you all for your time.
Is there anyone further here who would like to testify? Okay. Nobody else. Okay.
Great. And knowing that it's just well, I guess we're scheduled to go till 1:30.
I promise I won't take that.
No, what I was going to say is If after this there's no one else who's hoping to speak formally, then we can end the hearing. And if there are individuals who have specific questions about their own policies, you want to get a read from us informally, we'd be happy to stick around for a bit.
Right, and we will be here through the end of the scheduled period to conclude the hearing at the regularly scheduled time, but we'll suspend it during the break after this next test.
Okay, so I'll start just by following up on what somebody had talked about earlier with her concerns with respect to abuse. And I know you had said that, I know this is true, the intent of the law is not to allow people to just walk off the job and say I'm sick, or come in late and say I'm sick. But I think one of the challenges for employers is that the statute and the regs don't allow any mechanism for an employer to truly verify if somebody is actually sick or not. And like you said, if somebody gets a call from a school and says your kid's sick and they have to go pick them up, obviously that employee should be able to do that.
I'm sorry to hate to do this.
Oh, sure.
Can you just identify yourself?
Oh, I'm
for the
sorry. Yeah,
record?
Kimberly Klimzuk. It's KLIMCZUK from Scholar Abbott and Presser.
Okay, right.
Yep.
Thanks.
But yeah, so since there is no way of ensuring, or since the employer can't get any certification of the need for leave, the employer never has any way of knowing for that short of an absence whether the employee truly has an emergency they need to attend or if they are just leaving because they feel like leaving. So I think that's one of the challenges. And although it is a balancing act trying to allow people to be able to take that time versus being able to prevent abuse. And I think that's one of the reasons why the person who spoke back there had mentioned that having at least taking an hour increment would be helpful in doing that. And I know that you guys are limited with respect to what you can change in the statute, but I note that the language says that time off would be tracked in an hour increments or the smallest use of time the payroll system uses to account for use of absences or other time, period. And I think if you clarified in the regulations that it was use of absences or other time off, as opposed to use of absences or other working time, which is, I think, the current interpretation according to your frequently asked questions, then that might be something that you could do to assist.
On this, thank you for the comment, and we did make particular note of the minimum use comment. Back to the verification of any use of time, understanding that we've written in the opportunity to require employees to sort of verify in writing that they use leave for allowable purposes, but that is for some employers not a sort of sufficient safeguard against abuse. Is it your current recommendation to your clients that any absence taken come with written documentation? I mean, if somebody calls in and says, I'm sick in the morning, many of us, as we understand it, do not seek medical attention for, let's say, a one-day absence from work. We're just not well that day. We know that if we take some medicine and we go back to sleep, then we'll be better the next day. So what is it that you currently advise your clients?
Yeah, well, a lot of clients, we don't necessarily advise any particular policy because it depends on the organization and what meets their needs. But I do know what a lot of people do is they might have a policy that says, okay, we're going to allow you 5 freebies of unscheduled absences. And once you've used those 5, then we're going to start disciplining you, maybe with a verbal warning, written warning, so on. I know one of the things that this law, one of the effects of this law is that a lot of employers are just moving to a system of, okay, any unplanned or unscheduled absence that is not covered by the sick leave law is going to be cause for discipline. So it actually, in some ways, is harming employees in that respect.
Can you say that again?
Yes. So part of the issue is deterring these kinds of unscheduled absences. Because if somebody knows they're going to be absent and they tell their employer in advance, the employer can plan for that, and that's great. You can find coverage, or you can let the people know they're not going to be there. The problem really comes in, especially for some organizations, where they're expecting somebody to show up and that person doesn't, or they're expecting someone to be there for a full day and that person leaves. Mm-hmm. So for those kinds of unscheduled absences, many employers understand that those things are going to happen from time to time. You are going to get that call from the school. You are going to all of a sudden feel nauseous and need to go home. So employers will build into their policies something like, okay, you get 5 chances to do that, or 2 chances, or 3 chances to have an unscheduled absence. But then after that, we're going to start disciplining you for each subsequent one. But then now with the sick leave laws, people are saying, okay, your sick leave absences, unscheduled absences, those will be your unscheduled absences. But any absence that isn't protected by the sick leave law, we're going to subject you to our normal discipline policies. And that could be anything from if somebody leaves and has only accrued 2 hours of sick leave, but they end up taking 4 hours off, then that could lead to discipline in that situation. Because that second 2 hours wouldn't be protected because it wouldn't have been accrued under the sick leave law.
See, so we want to caution your clients that like willful attempts to get around the anti-retaliation protections of the sick leave law, understanding that you only have protection for time that you've accrued, but willful attempts to burden or to burden the right to the benefit, could be problematic.
No, of course, and I will tell you, none of my clients are trying to work an end run around this. They're just trying to manage their workforce, and so if they have people who are calling out, they need some way of managing that. And so they understand they can't do that for sick leave protected reasons, but once somebody has used up their 40 hours of sick leave, of course they could impose their normal disciplinary policies for unscheduled absences. I do think that switching to possibly a 1 hour minimum increment would help manage that to some extent, as opposed to somebody trying to track 12 hours of sick leave or 18 hours of sick leave taken.
Thank you.
And I think another interesting effect of this law is that it's almost harder for employers that already have paid time off policies to come into compliance than it is for employers who had nothing. Employers who had nothing, they just institute whatever the accrual rate is, all the policies that are prescribed by the law. And if you have a PTO policy that only gives 40 hours of leave per year, then that's pretty easy too. You just switch it all to compliance. The issue comes if somebody, and I have many clients who offer very generous paid time off policies where they might have 180 hours of leave per year or more. And now one of the benefits of a paid time off policy is that you are allowing the employees to have control of their own use of time. So if they want to use it all for vacation, if they want to use some of it for sick or all for sick, that's up to them, and they're responsible for effectively managing that time. And the benefit of a PTO policy for employers is that they don't have to track why they're taking the time. They just get it, they get it. With this, one of the issues that, for example, the minimum increment tracking does is that for people who have PTO policies that say you have to take PTO in half-day increments or 1 hour increments, now it's unclear what they can do with respect to a portion of that PTO. Do they have to carve it out and know when somebody's taking the leave for sick leave versus vacation leave? Can they just say, okay, the first 40 hours of your PTO policy, we're going to consider that your sick leave. We'll track the first 40 hours by the minute. Anything beyond that will be half-day increments. It's very unclear from the regs how best to manage that. And a lot of employers are having trouble because they can't really take full advantage of the PTO system because they feel like they have to carve out the 40 hours of sick leave.
What do they do for vacation time now?
Typically for vacation, it would be part of the PTO, and it would be taken in half-day or full-day increments, sometimes in hour increments as well.
Right. And what do they do with respect to the fact that under the wage and hour laws, accrued vacation time is considered wages and have to be paid out at the time of termination?
Right. They would still pay out whatever the person has left. But it's just that if somebody says, I want to take...
I'm sorry, just to clarify, When you say whatever they have left, are they parsing out vacation versus PTO? I'm trying to get at what they're doing.
Okay, so typically it's the whole thing. So PTO, if it all can be used for vacation, and if there's nothing else in the employer's policy saying otherwise, then the entire PTO bank, whatever the person is treated as wages, and whatever the person has left of their PTO bank would be paid out at termination. Okay. Of course, the Attorney General's office the Attorney General's advisory already says that you can designate a portion of your PTO as sick leave or other type of non-vacation leave, in which case only the vacation piece of it would have to be paid out as wages. So some employers have already done that. Some employers don't, but are some now are saying, okay, 40 hours is going to be sick leave, and this is causing some consternation even for employees who are saying, well, I don't want 40 hours of my vacation time taken out into a sick leave bank. I want to use it all as vacation, and so
they can't do that.
In some cases, yes. In some cases, no. If it's sick leave, it's sick leave, and it's protected.
Well, but they couldn't take it. I mean, all right. Go ahead.
So the intent as expressed in the statute, I mean, the law passed by the voters, is to say that if you provide 40 hours of paid time off that could be used for any purpose, then so long as the protections that we've discussed today around notification and documentation, non-retaliation were maintained in accordance with the earned sick time law, then no other change necessary. So if you took your 40 hours and went to the Cape for a week and then came back to work, that would be sort of consistent with the purposes of earned sick time, even though you might subsequently become sick and then have no protection under the law.
Right.
Because you'd have essentially used all of your protected time.
Yes.
So maybe we need to be clear about that piece number one.
No, I think that point is very clear. I think what's unclear is when somebody has PTO in excess of the 40.
You're raising a different question, which is the sort of what if you have 80 hours? What if you have 120 hours? What if you have 160 hours?
Right. Which 40 is your sick leave?
Which are the 40?
Right.
For which notification, documentation. Now, candidly, as has been expressed by so many, there are hundreds of thousands of workers for whom this is sort of an abstraction. They currently have access to 0 hours of leave, and the law was intended to focus, at least in its initial piece, on making sure that everybody had access to some amount of time. We are trying to figure out what the easiest way is to, and for all of you, what the easiest way is for those with generous paid time off policies, as you've suggested, to sort of fit into the law. The first thing we did was create this safe harbor that says if you're providing time off, then you have 6 months and you're in compliance with respect to all employees who have access to time and any other employees that you sort of allow access to time. But we would really appreciate your feedback on what would be easiest as we again work a balancing act to try to help everybody do this in the most workable fashion. Does that make sense? We could use some guidance here on what's easiest. Is it a mechanism by which people can designate, or if they don't designate, then you have an automatic system for attributing it to certain time? We could use some help figuring out what's going to be most workable based on really the systems that this needs to be tracked in.
Right.
Does anyone want to add anything on that topic? Elizabeth, and then sir, yes.
Do you want to come testify?
Yeah.
Okay.
Actually, we're going to need to ask you to testify.
I'm sorry, are you done?
I did have one more point, but
I
can share the.
Why?
Oh no!
Let's
sorry.
just finish,
Yeah.
please.
Okay.
It's all right.
All right,
we have to actually
Sorry.
keep. No, it's okay. It's 1:08 now, so it's been 10 minutes. So I just want to keep.
Okay, there's just one more thing, which is with respect to if somebody does not give their certification, the regs say that an employer can delay or deny future use of time. And it seems a little bit unclear because if somebody uses all 40 hours right away and then they don't give any certification, what recourse does an employer really have to deal with that? There's nothing that mentions anything about discipline. You certainly can't withhold the pay, or deduct any pay. It just says you can deny or delay use of future time. And that is a little bit confusing because if then somebody tries the next year, calls out, it doesn't seem like that provision would carry over into the next year. I don't know if that's making sense, but there doesn't really seem to be any true recourse for an employer for an employee who does not provide certification of their leave.
Thank you.
Okay, sir. Who was the first in the room this morning? He's finally decided to testify. Thank you.
Good afternoon.
Good afternoon.
My name is Mark Adams. I'm Director of HR Services with the Employers Association of the Northeast. We're a not-for-profit business association with approximately 900 companies throughout Massachusetts, Connecticut, and Rhode Island, about two-thirds of which are in Massachusetts. relative to, I have submitted written comments for consideration to the agency. However, in looking at that in the wake of some of the testimony that has arisen during today's session, I did have one thing that I did not completely address, and that was on the subject of paid time off. To Kimberly's point, first of all, I would agree that for a lot of companies who really are trying to provide generous benefits to foster engagement and retain people, because for them to operate a business successfully, their people are their most important, resource. And we find for most companies that we engage with, that's the case through looking at their policies and procedures and handbooks. We have found when it comes to paid time off that you do have a lot of paid time off banks, which certainly are, in terms of the sheer volume of time given, well above often what the 40 hours would be provided under the sick leave law, because a lot of times they're arriving at it through some formula, kind of projecting how much time they might anticipate might be used for recreational purposes, sick purposes, other purposes, especially if they've gone from separate time banks to a unified time bank, and they've kind of tried to evaluate how much they can afford to provide financially. One of the things that is that we have seen in a number of paid time off programs is for companies to require the use of paid time off before they can go into an unpaid status. And I guess when you're talking about paid time off, and to Kimberly's point about people managing the use of their own time, some companies provide specific notice as to why they're using it, but for many who don't have that, because the general principle of paid time off is they didn't want to be putting people in a position of having to give specific reasons they've otherwise deferred. I guess the one specific question I have, or two specific questions that I have, is for people who provide specific notice that they're taking time off pursuant to an established paid time off program that, for sake of amount of time and so forth, would meet what the current proposed regulations call for, and they give a reason that would specifically be enumerated under the sick leave law. Could an employer require that the time, in fact, be used? The whole issue that Kimberly talked about, whether the first 40 counts towards the sick leave requirement or some other time, not even getting into that specific, but could that time be required to be used, number one? And then the second question would be, putting that aside and going to the issue of someone who calls out specifically and gives a specific reason that is for recreational purposes and clearly would not fall within the gamut of the sick leave law. Could the time, in fact, be required to be used as a matter of policy?
Time, I'm sorry.
Could their earned sick time hours?
Their earned paid time off hours be required to be utilized, understanding that that paid time off is to be used for a variety of reasons, including but not limited to the sick leave law.
How does that involve the earned sick time law?
Well,
that last question. I'm trying to just understand.
Well, I mean, the question becomes, if the time is being used, if I have a situation where I'm using the time recreationally, I'm then taken away from the time bank. Is the time bank then not going to be necessarily then made available for sick purposes to the degree sick purposes arise down the road? And then, of course, that does raise the question then of what 40 counts towards it and what 40 does.
So I think what you're asking is, if I announce that I am, just tomorrow, I'm going to be out because I'm going to the ball game.
Right.
I have access to paid time off.
Mm-hmm.
You're asking, I think, whether an employer may attribute this paid time off also to kind of the part of the 40 for earned sick time. Is that what you're asking?
Well, I'm saying that the paid time off bank might have 120 hours in it. You're
Right.
looking to take 8 hours
Right.
to go to the ball game. Can I automatically make you take that 8 hours that I'm giving to you?
Make you take your 8 hours under your own existing private...
Right.
Well...
If you're not, it sounds like you're not talking about earned sick time right now, but rather can a PTO policy have rules about using paid time for?
And then maybe I'll
Are you asking whether or not an employer may require use of paid time off when an employee is looking to be absent from work?
Right. Maybe I'll put it in a different context. What if the paid time off bank, which is going to be used for just the sick leave law, as well as recreational purposes, is only provided at an amount of time of 40 hours total, and you're out for recreational purposes?
So that question is explicitly addressed in the law, which is to say, if you spend 40 hours at a series of ball games, right, then and that time is made available to you in a way that it could also be used for the purposes envisioned under the statute, then an employer need provide no additional time.
And maybe I should be clear, because the question might be one of, what if the person doesn't want that time to be used, but they're being made to use it?
But and they want to use it. They want to do what? You're talking about the use of vacation time, like recreational time off.
Paid time off that would be used for recreational, vacation, sick, or other purposes.
Are you saying I want to be out from work, I don't want to get paid today, I don't want to use my paid time off?
Because I want to bank it for other reasons down the road.
You mean today I'd prefer to be absent and not paid?
Right.
Well,
That doesn't really go. It's not addressed by the Earned Sick Time law. It's not covered. There's no state law that really gets to that.
Okay.
Because it's not regulated. But I think what Mike was saying, when there is a pot of time that has to be, can be used for earned sick time, and the employer has an existing vacation policy and they want to extend that to cover their obligations under sick leave. That's all the employee has. And I think, as Ms. Toulon was mentioning, a lot of employees consider that sort of like insurance, so they're not there, or very special times, so they're they might want to hold it. But an employer could have a policy that requires use of time. I know that I work for the state and I can't just go, take me off the payroll next week. I don't have a right to do that, to get not paid time. To be off without being covered by time.
Okay.
So
to the degree that can exist in a singular policy that's used for both the reasons under the law and otherwise, that's great. I was just there was some provisions in the regs that were somewhat at odds with that. The other piece I wanted to ask, I wanted to raise the question on, is the current proposed regulation as drafted as it pertains to notice. The current proposed regulation stipulates that, of course, consistent with the statute, that the Attorney General would be crafting a model notice, which that's what the law says, and I wouldn't have expected otherwise. And that's consistent with a variety of other subjects like wage and hour, unemployment, workers' comp, et cetera. But the proposed regulation goes beyond just the mere notice requirement, requiring also the posting of these regulations, is the term in the regs, and to provide a copy. And I guess my question is, that seems like a bit of overkill, especially where on top of that, all of that also information is going to be accessible through other means. Was the intent just simply to have that in that form with the potential that maybe the proposed regs would have only been governing effective July 1, and that when the final regulations do in fact get released, that the notice requirement might be receded down to simply a notice requirement?
I just want to craft. Sorry, I think you're reading, for those following along, this is 3309 subsection 4. You're reading, employers shall post a notice of the Earned Sick Time Law and these regulations prepared by the Attorney General in a conspicuous location, to mean that you need to post a notice and these regulations. But it's just notice of the law and the regulations. So to the extent that the commas there are confusing, we will clarify the intent, which is to provide notice to all employees. You don't need to print a copy of the regulations.
Do you also have to distribute the notice too? Because I think it also says to provide a copy to the employees too.
Does that say that?
What's that?
Just so you know, we are planning to. I'm sure all familiar with the old wage and hour posters that used to have a picture of an attorney general and the laws. We are sort of in the midst of redoing that to bring the earned sick time in. So that mandatory poster will cover both the earned sick time and all the wage and hour laws that need to be up there. And I think that will help to sort of save space on folks' walls and make it clear that people are very aware of this. And I just want to, I think that with respect to your first question, the provisions you might have been thinking about when you were talking about the requiring paid time off, there is a part of the regulations that says that employees can choose to use covered time. Time that they have that's paid time. Say they have vacation time, and it's not a PTO, but they have vacation time.
Mm-hmm.
They have sick time. They have vacation time, but they work for a company that has less than 11 employees, so they are not covered by the paid provision of the earned sick time law. They can use their otherwise accrued paid time off, their vacation time, to cover what would otherwise be unpaid time off. It's not a windfall, it's just using other time to cover it. And that's consistent with the Family Medical Leave Act. You can also do the same. So I think that's probably where you thought there might be a little bit of tension.
Okay.
Thanks.
Very good. Thank you.
Thank you.
And then we had another point from Ms. Tulin on the same topic.
Oh, okay.
And then ma'am, we will have you come up right after. And then I think we'll be pretty much at 1:30.
All right, thank you very much. Again, Elizabeth Tulin, Senior Attorney, Greater Boston Legal Services, and I just wanted to share, the view that we're taking of this flexibility around the use of PTO time to meet the requirements of the sick time law. The dilemma I know from our work on this for over 10 years was, what happens when an employee has only 5 days and they use it all up on vacation time. And our understanding all along, the way the law is written, is that if an employee elects to use all of their PTO and they only get 5 days, for vacation time, they're out of luck if they get sick. That's just going to be an unfortunate situation. And in the original bill, an employer had to provide over 20 days of PTO. And the point then was an effort to at least preserve some vacation time for employees. And along the way, the bill was compromised, and the ballot initiative reflects that compromise. So it went down considerably. I think the main point, from the point of view of the very low-wage workers that we represent, is this: that right now there are a lot of workers who enjoy some kind of paid time off, who enjoy some kind of sick time even, but when they use it, they suffer demerits. And the bill's effort primarily is to protect jobs and access to income and to allow workers to meet the needs of their own health and that of family members. So there's an effort to say, if people are using their sick time and it's allowable, they won't be punished. So if the PTO doesn't allow someone to call in on short notice when an illness is not foreseeable, i.e., I'm at the ER right now with my child who has spiked a fever, or I am, evading domestic violence and seeking shelter with my children in tow, that I'm not going to be told that, no, you can't take the PTO because you've got to give us 7 days notice. So this is what is required, that there wouldn't be punishment, that when the absence is not foreseeable, that the notice requirements of the PTO don't attach. Those are the things that we're urging employers who are generous enough already providing paid time off just to look at that. I think it would be great to get as much input as possible from HR departments and HR professionals on. Understand the whole point of PTO is put it in one bucket and not be burdened with parsing it out. But on the other hand, if a certain amount of time isn't segregated and subject to the protections of the sick time law around anti-retaliation and the notice provisions, then in fact there's a good question about whether or not the PTO policy would meet the requirements of the law.
Thank you.
Thank you very much. My name is Sarah McKee. I live in Amherst. Hi. I'm here because of notification of the hearing by Mother Woman and by Western Mass Jobs for Justice. I am a former trustee of the Jones Library in Amherst. Of our more than 50 employees, well over 20 are part-time, non-benefited employees. And I've been instrumental with some other people in urging the town, even though towns are not covered by the new sick leave law, to accord our part-time, non-benefited people with sick leave as a basic human right. We feel very strongly that employees should not have to beg for it. And we feel strongly also that the voters of Massachusetts have spoken. They want sick leave paid, and they want it to go into effect on July 1st. This is not a surprise to employers. So I have not studied the proposed regs, and I apologize. I have no illusions about the difficulty of writing regulations. I have done it myself as a federal employee. But I would urge you to get the final regulations in effect just as quickly as possible. The detriments to the employees now with no sick leave, whom this law is intended to benefit, are dire. And I am sick at heart when I know that some of our library employees have had to be off for surgery with no income and no benefits. I should say they are town employees. It is not simply up to the trustees what we can pay them. So with a vivid appreciation of what you all are up against in crafting the regulations, I urge you, please keep faith with the voters and keep faith with many of the minimum wage people in this state who have been suffering quite, in my view, unnecessarily. And I thank you for sitting here so patiently these 3 hours, and would be glad to entertain questions if you have them.
Thank you.
Thank you.
I have no question. No, I'm going to add something. I just want to say that if you are after the regulations are finalized, if you are part of a business association, of a community association, your church, I'm going to leave my contact. You can reach out to the Attorney General's office, and we are planning on going out and to do community education about the law. So you can reach out. Unfortunately, we do not have the capacity to go to your company to do it, but if you're part of an association, a bigger group, that you'd like us to go and provide a community training about the law after it's finalized, the implementation of the regulations, we'll be happy to.
And I'll add that for individual employers or employees with specific questions, you can email us at earnsicktime@state.ma.us. I think we have a handout that has that
We do.
written on it, but anybody with a specific question, we answer questions all day, and we're trying to do it as quickly as possible, and we'll continue to have that manned after the law goes into effect.
Right. And just as a reminder, we will have the final regulations up on the website for the Attorney General's office on June 19th. And effective date of the law is July 1st. If there is no one else who would like to testify at this point, it's 1:28. We will suspend the hearing for the next 2 minutes before closing out the hearing.
And our thanks to Paul, who's been doing the recording.
Right. The Earned Sick Time hearing in Springfield, Massachusetts on May 29, 2015 is now concluded. It is 1:30. Thank you.